So just get that right, just get the recordings going then, folks. And that's 4 o'clock. So are we ready?
Yeah.
Yeah. Good. Okay, I'll just start it then, and I'll just give it a couple of seconds or so for everybody to start joining. Oh, that's good. Well, good afternoon, everybody. I hope you're all enjoying the heat. I'm sure that a lot of you working from home probably wish you were in the office at the present time with nice cool air conditioning. But so a very warm welcome, both literally and metaphorically, to this webinar this afternoon. This webinar is being recorded, so if there are any points that come out of the webinar that you find of interest or you want to refer back to, you will be circulated with a copy of the video of the webinar in a couple of days' time. And again, indeed, if you want to pass it on. As people are just joining, I'll just introduce myself. My name is Elias. I'm a relationship director at Thrings, and this webinar is part of a series of webinars that we've been running all the way through the COVID pandemic, just to update our clients and our fellow professionals in terms of the key aspects which are happening in the market at the moment, in terms of the various sectors of law that we look after. Today's webinar is going to have a property focus, and that's mainly around the relationships between landlords and tenants. So I'm joined by 4 of my colleagues from our property litigation and insolvency teams for this afternoon's webinar. So we've got, as you can see, we've got 4 speakers in total. First off, we have got Michael Tatters. Now, Michael is going to give us an update in terms of COVID legislation and particularly in terms of landlord enforcement options and respite schemes, etc. Second up, we have Matt Smith, and Matt's going to give us an update in terms of tenant exit strategies, looking at break clauses, issues around dilapidations and things like that. Following that, obviously, you can see we've got the roads between all the thorns. Amari Rajendran is going to give us an overview of Landlord and Tenant Act terms, particularly in terms of renewals, but also looking at new leases as well, really, in terms of what we should be considering in the current environment. And then finally, we've got Mark Cullingford, who is going to sort of take us through what insolvency considerations both landlords and tenants should be considering in the current environment. So there's a lot to get through, so we won't delay any longer, other than to say that this will be an interactive webinar. I have a couple of polls which are very, very general, very generic, which I'll just run, and it's purely for a little bit of market research from our perspective. So we'll pick those up throughout the course of the presentations. Also, there's, as you can see, there's a Q&A section as well. So if there are any burning issues that you'd like to raise, please pop them down on the Q&A section, and if we have time to cover them, we certainly will do. If we don't have time, we'll pick them up at a later date, or indeed if they are of a more personal or specific nature, that's where it's not appropriate to discuss them with a live audience, we will pick those up directly with you as well. So, as I say, there's a lot to get through. So, we'll start off with Mike. Mike, now the Coronavirus Act 2020 is a topic that we've covered a couple of times in the past. It's had various extensions over recent months or years even now. So, what's the current state of play? Where are we now?
Yeah, thanks, Chris. Afternoon, everyone. Who'd have thought some 15 months later we'd still be talking about landlord restrictions and COVID issues, but well, here it is. And just to recap, the government introduced these restrictions back in March of last year. They originally introduced them for 3 months, and thereafter they've extended them every 3 months. I think there's been about 4 extensions every 3 months. And then we came to June when the deadline was due to expire, and the government went into consultation with the property industry, and there was some question marks as to whether these restrictions would be taken away or whether they'd be extended, or perhaps there'd be a mixture. Well, they've plumped for quite a significant extension. So the new rules that are now in place are extending the landlord's restrictions for 9 months. So that's a considerable extension. And the government have introduced a new aspect of the concept of arbitration, and I'll talk about that in a bit. But the essence of the government's legislation is encouraging dialogue between landlords and tenants. So they introduced the code of practice, and they are seeking to encourage landlords and tenants to enter into negotiations and agree terms. And in the meantime, they've put the restrictions in place on enforcement options.
Okay, so what are the main aspects of the current extensions then, Mike?
Okay, so there's threefold. We've got the normal tools in a landlord's armory are the power to forfeit the lease. That is, the moratorium has been extended, and that's been extended for 9 months to the 25th of March 2022. In Wales, it's only to 30th of September 2021, and that will be no doubt reviewed in late September. So that's forfeiture. Landlords cannot now forfeit, or still cannot forfeit, for non-payment of rent. Then you've got restrictions on commercial rent arrears recovery, which is CRA, which is bailiffs attending at tenant premises to seize goods. They are also restricted till 25th of March 2022. So again, a significant extension. Then we've got the restrictions on insolvency processes, and Mark will talk about these later as well. But a landlord cannot now serve statutory demands to wind up tenants, and those restrictions are in place till 30th of September 2021. So a slight divergence there. The other two are till next March, the insolvency till end of September. So there's a bit of a change there, but inherently they're extending the limitations on landlords' enforcement options.
Cool. Okay. So in terms of the moratorium on forfeiture, does that apply to all leases, or sort of some excluded? Does it just cover rent or other things?
So it's designed to include all business leases. So that's protected business leases and contracted out business leases. So all business leases have this protection, and the rent that is protected is not just pure rent, but it's all forms of payments under the lease: service charge, insurance, interest. So all these forms of payments under the leases, if they're in arrears, the legislation protects them and creates this moratorium. So that really does restrict landlords' enforcement options.
Okay, cool, good. Now I'm just going to launch our first poll. So whilst that's being launched, we'll just sort of progress things as we go along. So I think one of the other things that has come up, I think, is in terms of the ring fencing of a commercial tenant's arrears. What's the update in terms of government legislation covering this?
Yeah, so this is the new one. This is the government's new legislation. It's not in place yet, and we're expecting it sometime in the autumn. And at the moment, to be fair, there are far more questions than answers. But just to summarize this, what the government are going to introduce, what they've announced, is an intention to introduce new legislation in which landlords and tenants will be legally obliged to negotiate and try to resolve rent arrears. And if they're unsuccessful, they have to submit to a binding arbitration process. Now, that in itself is quite significant in terms of, here are some of the questions people will be asking. What arrears does this relate to? Is it just arrears during the pandemic? What about future arrears? What type of businesses or sectors will be able to take advantage of this? Will it be just businesses that have closed during the pandemic? So there's a lot of questions here, and the government again emphasizing that landlords and tenants are expected to try to come to an agreement. Well, what about the terms that have been agreed previously? Because there'll be plenty of instances where landlords and tenants have reached an agreement already over arrears, and what will happen to those remains to be seen. But there is this emphasis on entering into a dialogue, and then if those are not successful, it going off to an arbitrator. Now, these arbitrators' powers are potentially quite wide-ranging, and again, they probably need to be clarified, but who knows how extensive they will be. Will the arbitrator be able to waive some or all of the rent arrears, service charge arrears and other aspects? Will the arbitrator be giving the tenant more time to pay? Will they be giving sort of an installment plan for tenants? Will they be resetting future rent? Could they even be extending or reducing the term of the lease or deferring certain obligations? Lots of questions there, and at the present we're not too sure. So I expect the industry is very keen to hear further from the government as to exactly what they intend to do with the arbitration process. In addition, the arbitrators could be deluged with a huge number of cases. So how many arbitrators are there? How quickly can they get trained up? Will there be a delay in this process? Who knows? So a lot of questions there, and I probably won't be able to answer many of them yet, but it's certainly going to be a significant change in the landlord and tenant relationship, I suspect.
Good. So as you say, more questions than answers. There's a song there, isn't there? But anyway. Right, so let's have a look at the poll results, which I'll just share quickly. And just interesting to see just 10% have seen action being taken, but 80% have not seen any action at all. So that's an interesting statistic in terms of the vast majority of people have not experienced anything. So an interesting point there.
I suppose that reflects that most landlords and tenants have reached agreements, or they've agreed some form of agreement whereby some rent concession is in place, or maybe some installment options, or monthly rent instead of quarterly. There's a whole range of options there.
Well, I think that's encouraging, really, isn't it? That people continue to negotiate rather than having to sort of come to the final hurdle, so to speak. So that's good. Right. So I guess then, in terms of the landlord, what other options would they have to recover any unpaid rent?
Well, the main option they've got is, if they wish, and I don't see many landlords doing this, but they can sue the tenant for the debt. So the lease remains in place, and they can take a county court action for recovery of the rent as a debt. And there've been two recent cases recently where landlords have taken court action against tenants, and the tenants have come up with a whole host of potential defences. And the appeal courts have made rulings in two recent cases of TFS Stores and Cine UK. And it's useful just to run through all the various arguments that the court have rejected on the part of the tenant. So the tenants have argued that the landlord has not complied with the code of practice by going to court. It hasn't sort of negotiated with the tenant. Well, the court said it's not obligatory, so that's not a defence. The tenants have argued that the landlord should have insured against rent and recovered via the insurance process. The court said no, they don't have to. In most commercial leases, there'll be what is known as a rent cessor provision, whereby rent will be suspended if the property is damaged. The tenant argued, well, COVID was a form of damage, but the court said no, it's got to be physical damage, so that wasn't allowed. The tenant argued that there should be an implied term in the lease that rent should not be payable during COVID because it was such an exceptional event. Now the court rejected that. And then there was an argument about frustration, which is a concept whereby if the contract cannot be performed, the rent shouldn't be paid. Well, the court said, yes, that is a principle, but because COVID is temporary and it's not permanent, the tenant didn't succeed on that argument. It seems harsh, but because the tenant, obviously, some tenants will not have been able to trade from their premises, but the court rejected that. So overall, the court ruled that the landlord was allowed summary judgment for the rent arrears, and the tenants' arguments were rejected, all of them. Now, how that sits with the arbitration process, because on the one hand, the court is saying that the landlord is obliged to recover these rent arrears in full, whereas the arbitration legislation is suggesting there needs to be some form of agreement, and potentially with the arbitrator allowing some of the rent arrears not to be paid. So the two potentially don't really fit together, but at the moment, the courts are very much coming down on the side of the landlords. Okay,
so if the court's coming down on the side of the landlords, then what do the tenants have any other sort of options? Any strings to their bows that they can sort of fight back with, so to speak?
I suppose one aspect that the tenants could take advantage of, and unfortunately this is just for individual tenants, not for corporate tenants, is the new debt respite scheme, which was introduced in May of this year, which enables the tenant to apply for a moratorium period if they are suffering because of COVID. So they can apply for two different types of moratoriums. There's the breathing space moratorium, which lasts for up to 60 days. And there's also a mental health crisis moratorium, which lasts for however long the mental health issue lasts, and an additional 30 days. So the scheme is available for individual tenants if they have a qualifying debt and that they show that they can't pay the rent because of COVID. And the effect will create a moratorium, and the landlord cannot enforce to recover the rent arrears. So that's something there for the tenants to use for particular tenants who are suffering most significantly.
So just to clarify, that's for individual tenants, not corporate tenants, did you say?
Yeah, that's correct. That's correct. So it's not available for corporate tenants. No,
right. Okay, cool. Great. Okay, Mike. Thanks. I appreciate you have covered an awful lot of ground there, but yeah, that's really good. I'd say any questions coming out of that, please jot them down, and we'll do our best to answer them.
There's a lot of detail there, and I have scanned through that in pretty quick pace. Yeah.
No, well done. Brilliant. So thanks, Mike. Appreciate that. Matt, I think you're next up into the hot seat, and I suppose really I wouldn't be surprised if the majority of the people on this call this afternoon are probably sitting at home as opposed to being in their offices. So I would imagine there are lots of commercial businesses out there that are reassessing their need for office space and possibly vacating existing premises, downsizing. What sort of legal issues should they be sort of considering at the minute? What should be at the forefront of their mind if they're looking at doing something like that?
Yeah, thanks, Chris. Afternoon, everyone. We do see a lot of these types of inquiries. So we're talking about business tenants here occupying under a written lease, hopefully. The first thing to consider is whether it's Landlord and Tenant Act 54 protected or not, and the duration of that lease, the term of that lease. So if you're under the Act, term might have finished, and you might be under the statutory continuation. So you can serve 3 months notice, section 27 notice, to bring that to an end. Otherwise, tenants are going to need to wait until expiry of their leases, unless they've got a break clause in their lease.
Okay, and so if they have got a break clause in their lease, what sort of things do they need to look out for then?
Yeah, break clauses are often couched with conditions. So not only have you got to get the service of the break clause absolutely right, it's high risk area. If you get that wrong, your break's not effective. But you also, if there are conditions attached to the break, you've got to get those right. Otherwise, the lease just won't break. So it'll continue on for the rest of the term. Typically, conditionality-wise, we'll see tenants would have to pay a premium or pay all sums due under the lease at the break date, or deliver up vacant possession of property at the break date. Those are the sort of typical conditionality that we'll see. So if tenants have to ensure that that there are no arrears, they've paid everything, then they should always pay the full quarter before the break date. Not apportionate unless the lease says otherwise or the break says otherwise. And if tenants have ever paid any sums late, then they'll need to check the term of the lease. Are there any interest provisions that would apply? Because if there are, then those sums would need to be paid subject to the terms of the break and terms of the lease. But yeah, they would need to be paid. And if the tenant gets that wrong, then the lease isn't going to break.
Okay, cool. Now you mentioned the term vacant possession there. In my, going back to my banking days, we always used to ask for valuations on a vacant possession basis. In legal terms, what we're talking about now, what does vacant possession actually mean between the landlord and tenant relationship?
Yeah, we've got vacant possession or full vacant possession, so generally the same thing, except to mean the same thing. And it's delivering up the property free from people, chattels, and interests. So it's quite burdensome, I'm afraid. There's a lot of case law in this area where tenants have vacated, but they've left bits and pieces in the property. Then the question is, what are those items, are they chattels or tenants' fixtures? It seems to be a rather arbitrary difference between the two, but there is a stark difference, and the consequences are severe if the tenant leaves chattels, a substantial number of chattels in the property. So a chattel is an item that's tangible, movable property, so it's sort of like a clock or a table or a chair, whereas fixtures are items that are fixed to the land or the building itself. And items are either chattels, fixtures, or part and parcel of the land. And the courts have developed a flexible test to determine what we've got, so whether we've got a fixture or a chattel. So they'll look at the extent to which the item is annexed to the land. So is it part of the physical structure of the building? Can it be removed without destroying it? Would it be effectively useless if you took it out and put it somewhere else? And then also look at the purpose to which the item was brought onto the land or annexed to the land. So is it a lasting improvement to the property, or is it something that the tenants brought on for their own benefit, their own purposes? So it's a bit technical. Each case is decided on its own facts. But where you've got fixtures that have been left in the property, then there isn't a problem for the tenant, unless the tenant was required to remove them as part of the break, or as part of the license that allowed them to put them in the first place, or if they're unlawful and they had no license in the first place. But compare that to, contrast it to chattels. So if those are left in, then the court will need to go on to consider whether those chattels essentially prevent the landlord, or substantially prevent the landlord from occupying after the break date. The test is whether the chattels substantially prevent or interfere with the enjoyment of the right of possession of a substantial part of the property. It's a bit of a mouthful, but essentially what it means. So where the tenant fails, then it would have failed to deliver up vacant possession if there are a substantial amount of chattels in the property. So this often comes up with partitioning and kitchen areas. There's a well-known case of Riverside Park where partitioning and a kitchen were held to be chattels, and tenant wasn't successful in providing vacant possession. It didn't remove those items. But it's a really difficult balance for tenants. There's a recent case of Capital Park, Leeds PLC and Global Radio Services, where the High Court had initially decided that where the tenant was required to deliver up vacant possession of the premises, it actually failed to do so because it had removed too much of the property. So it had gone the other way. And it was sort of taking the property back to shell condition in parts of it. So it delivered up less than the premises, which is what the break clause required. It required delivery up of the premises. But that decision, thankfully, for tenants anyway, has been overturned by the Court of Appeal. And the court decided that on construction, that was not what the parties had intended. So it was a fine point there, but yeah, good news for tenants. That was a decision earlier this month. So essentially, tenants can sort of err on the side of caution, and they can take too much of the property out, and they should be okay on the break. Although landlords would be able to come at them with a damages claim ultimately for disrepair of the property, so they don't get away scot-free.
Right. Okay. Then. So, in summary, then, what are the main things that that tenants need to do or consider? Yeah,
it's all about planning it. Really need to look at these things, say 12 to 18 months in advance. Check those lease terms carefully. If there are any breaks, what are the dates? What's the notice that's required? Often 6 months notice. Get involved. Legal surveying advice early. What needs to be done and by when? Tenant solicitors should serve the break notice. There's really high risk getting that wrong. So solicitors do that. Consider that conditionality really carefully. Clear timeline of works that need to be done or payments need to be made, and make sure that everyone is aware of that. Contractors know when they need to get in and out by. If vacant possession is required, then we've got this chattels fixtures issue. So another reason why want to get legal advice and surveying advice in early. If tenants got time, then they might be inclined to engage with the landlord and see whether they can agree what works need to be done to deliver up vacant possession. If the landlord will engage and talk to the tenant, that is. If break conditions are particularly onerous, then really the best way is to try and settle it. So offer the landlord a sum of money and agree a surrender of the property. Where break conditions are uncertain, then it is possible to apply to the court for a declaration, but it's really sort of last resort, given the time and cost that will take, and really needs to be done early. Tenants should also factor in and budget their dilapidations liability. So they might want to try and settle that off as well as the break conditionality. So if they do, they just want to double check, do a bit of due diligence to make sure that the landlord isn't planning to demolish or redevelop the property, because that would affect its overall dilapidations claim before it pays any money. So yeah, just ensuring that someone who understands the risk really is managing the whole process, and making sure they get those contractors and keys and people out of the property in good time before the break date.
So it's not a spur of the moment decision at all, really, is it? Actually, Mark shaking his head as well there, but it's something that you really need to plan if you're going to do it successfully, and with the least risk. You really have to sit down long and hard, haven't you? You really do. It depends on the conditionality, but yeah, you really do. You need to have sight of that and know what you've got in store and got to deal with early. Cool. Okay, great. Well, I'm just going to just launch another one of the very general polls. So that'll run now while we sort of pick up with the final point, which I know Matt wanted to cover, and that was we've looked at exit strategies from a tenant's perspective. What about the landlord side of the coin? What should landlords be looking at? Yeah, generally landlords don't really need to have to engage. It's the tenant's problem. But that said, if there are alterations that the landlord would want left in the premises that the tenant's carried out, then they might want to agree those. Landlords should always check provisions for reinstatement if they want certain things reinstated. Landlords might also want to consider serving a schedule of dilapidations. If they are going to settle the delapse, then there's some tricky HMRC VAT rules, which mean that that could be charged retrospectively, payable retrospectively. So they want to settle that off on the basis that the tenant pick up the VAT for any delapse settlement. And they should definitely inspect the property immediately after the break, go in, take photographs, anything's left in the property or scaffolding outside of the property, document it. We acted on a case where tenant had left scaffolding up and various bits and pieces in the property beyond the break date. And we argued for the landlord that the lease was continuing. It eventually settled at mediation, but there was a considerable sum paid by the tenant to the landlord to ensure that there was no future liability under the lease. So tenants really do need to be careful, be on the ball. When the landlord's given those keys back, landlords should state that they're held to order and they shouldn't accept that the property has been handed back until they've carried out that inspection post-break. Don't accept it, don't admit it, sort of thing, as you would say. Okay, good. Right, so if I just share the results of that last poll, and that is quite interesting, really. So 67% currently looking to downsize, 20% currently considering it. So that's 87% in total are currently, either going through the process or considering it very seriously. So, I think that's an indication what's likely to happen to the market out there, isn't it? Really, in terms of issues for all sorts, for landlords, for lenders, or all, it's across the sector. Yeah, there's a lot of change, isn't there? Potentially a lot of break notices to be served there. You might be busy, I think. Lovely. Well, anyway, thanks very much for that. That's been great. As I say, we've dashed through that, but that's been marvelous. So, Amari, you're in the mastermind chair now. Your turn. So I guess we mentioned that we're going to sort of specifically look in terms of how COVID is impacting on lease renewals or new leases. So what's particularly relevant at the minute?
Yeah, thanks, Chris. So yes, so as Michael went through, there have been lots of immediate and ongoing changes and impact on the commercial property market generally, in particular to existing leases and how non-payment of rent has been dealt with. What we're also seeing is an impact on terms contained in new leases being entered into, in particular under lease renewals under the Landlord and Tenant Act 1954. So lease renewals are very common. I'm sure if any landlords, tenants, agent valuers are listening, they will possibly have dealt with them or deal with them. And they're coming around more frequently now with shorter lease terms. So so say you might have the average term at the moment of about 5 years. So every 5 years, a tenant might be looking to renew a lease, and you're also seeing more break options to give tenants flexibility. So broadly, assuming a renewal is not opposed, which follows a different procedure, a standard 1954 Act statutory unopposed lease renewal allows the tenant to request a new lease on broadly the same terms as the existing lease, and subject to the rent being updated to a market rent. And there are other factors to consider, such as modernisation or updating. So pre-COVID, an average run-of-the-mill lease renewal would have generally been focused on the level of rent to be agreed, which comes down to the valuation evidence and also possibly the odd term in dispute. So perhaps one party suggesting a term to be included and the other party not agreeing to that. And again, it tends to come down to whether a specific clause is reasonable modernisation or a current kind of accepted market term in the circumstances. So at the moment, so we've seen that COVID, unsurprisingly, has had an impact on what would be considered market terms at the moment for the purposes of a 54 Act renewal. And given that there's been a significant impact on market conditions, it follows that market terms have changed. Okay, so market terms, as you mentioned a lot there. How are market terms decided on, and what sort of what terms are specifically included or impacted? So I think so. I guess the answer to that is normally lease renewals are agreed by negotiation, but if not, then the 54 Act provides a regime for agreeing terms of the new lease. So the main ones, so term length and the rent. So rent comes down to market valuation evidence. The term length is governed by the Act as well, and a court, if being asked to decide the length of the term, will consider all sorts of factors such as current term, what the tenant needs to protect to them continuing to operate their business, each party's reasons, etc. But as for the other terms, in a court deciding, they need to have regard to all the terms of the current tenancy and all of the current circumstances at present, so that i.e. the day the lease is being agreed. There's a leading case on how terms are decided, and that's the O'May case, O'May and City of London Real Property Co., which is a 1983 case, and that clarified how lease renewal terms are agreed, and that is still good law, and that's what parties refer back to. So there are some principles that are accepted which were established in the O'May case, and essentially a party proposing a variation to a new lease has the burden of showing good reason for doing so, and that reason must be based on fairness and balance between the parties. So second principle is, if a variation is successful, then would the other party be adequately compensated by money? So just as an example, you might have a lease where there wasn't a break option in the old lease and the tenant might be proposing a break option, in which case the court would then think, well, hang on, does the rent need to be higher to balance out that flexibility the tenant's getting as against the landlord's interest? And just the other two are whether the Act is supposed to protect the tenant, so it's whether any change would materially impact the tenant and their business. And finally, just all relevant matters and whether a change would be fair and reasonable. So I've used the word fair and reasonable a lot there, but that is essentially why the Act is there and why these principles are there. It's all about balancing between the parties, the risk and the fairness. So that is why I think these principles are at the forefront of everyone's mind at the moment as a result of COVID and the damage caused, because obviously one party is going to take a hit there if a tenant can't pay the rent. And I think one point to note is lease renewals pre-COVID rarely got to the court hearing stage. They're normally settled by negotiation. I think normally you're dealing with commercial entities, so there's probably a reason to settle quickly, and it could be that the cost of litigation kind of outweigh any arguments or rent that you're arguing over. But since March 2020 and COVID, we're seeing more heavily contested lease renewals dealing with new arguments and new proposed terms. So I think just to give you an overview of the couple of terms that we're seeing being discussed a lot more at the moment are the level of rent, which, as you can imagine, the market rent has changed over the last 18 months or so, and the knock-on effect of that is the interim rent. Of course, taking retail tenants as an example, that makes sense. Stores are closing, there's less footfall on high streets, there have been several lockdowns, so all of these factors will have an impact on what the market rent is. The second term that we're seeing a lot of discussion over is the so-called COVID or rent suspension clauses. So these are new clauses that are being proposed by tenants, whereby they want to contractually deal with what happens if, say, there's another pandemic lockdown, or what happens in the future. So I guess the reasoning behind that is this was unprecedented, and so the government had to step in and stop leases being forfeited or encourage parties to negotiate, whereas now we know this is ongoing, possibly life going forward. So parties want certainty. They want to know what will happen if and when this happens again. I guess so. There's the principle of these rent suspension clauses to start with, and also the drafting, the detail where parties may get into a dispute over is exactly the circumstances and as to when such a clause would kick in. Because of course, some tenants have not been impacted by lockdown, they continue to trade, and they stayed open. So the circumstances are different for that type of a tenant to a tenant who's been forced to shut by the government during lockdowns. So actually, we have seen a couple more cases than we would have normally seen dealing with these points.
Is there anyone in particular that you'd any case you'd worthwhile giving us a little bit of a heads up on?
Mm-hmm. Yeah, there's the W.H. Smith's case. So that was W.H. Smith as tenant and Commerce Real Investment Gesellschaft, who were the landlord. That is a 2021 case, and that dealt with W.H. Smith's property at the Westfield Shopping Centre in London, the Shepherd's Bush one. So briefly, the facts here were the Smiths were considered an essential retailer, so they did stay open during all the lockdowns. They did continue to trade. So the main 2 points on that were the ones I just talked about. So the rent was disputed, and the wording of the COVID or rent suspension clause was also disputed. So this went to trial, and taking the rent suspension clause first. The landlords argued that this should only kick in if W.H. Smith's actually closed. So they argued, well, you continue to trade, so you should continue to pay rent. The tenants argued that the clause should kick in if there was a closure of non-essential retail, even though they were classed essential retail. The reason for this is that they said there was no advantage to them staying open. In fact, they said they were forced to stay open as a result of their banking and postal facilities. So they were actually required to stay open. But because of the lack of footfall in the centre, they actually suffered a loss. So their sales went down, I think it was something like 90%. But they still have the cost of having to keep paying staff, etc. So the judge ordered in this that the new lease should include the rent suspension clause in line with what WH Smiths had asked for. So it was a 50% reduction in the annual rent when there was a closure of non-essential retail. So the judge sided with the tenant. The factors here were that the Smiths actually put forward very clear evidence of the lack of footfall, the drop in sales that they could show immediately when there was a lockdown. I understand the judge actually visited the Westfield short store in November during a lockdown, so he could see that it was literally empty. So that was all compelling evidence. And some other ancillary points which weren't part of the judgment. The judge said that, so in principle, a COVID rent suspension clause was agreed here, but it was just the wording. But the judge had said even if the landlord had opposed one, he would have insisted on one being included. And the other point I mentioned, going back to the OMA principles, was whether one party should be compensated for a term being included. So the judge said no. So the landlord shouldn't be able to command a higher rent in exchange for including such a clause. And that was because he saw this as, now this is going to be a market norm. This is what tenants will want, and that's what landlords will have to give them. And just quickly on the rent point there. So the rent, of course, each party were at the other end of the scale in terms of what the new rent would be. And actually there was a significant drop. It was 50% drop, more than 50% drop from the current rent. So briefly, I think the judge put forward sort of what was based on expert evidence, but a sort of percentage reduction on various factors. One obviously being COVID, another to do with the location of the premises, etc. So I think that's something to bear in mind. That's a significant shift. And with interim rent, just a quick point, normally the interim rent is almost always the new rent. Here, as the rent was coming down, I guess that's slightly more unusual, but the interim rent was essentially at 75% of the previous rent. So they almost split the difference, really. And I think probably the relevance of that is this was over a long period of time, but obviously COVID had hit during that time, so there would have been an impact on the rent. And I think so essentially the judge did favour the tenant here. I'm just going to mention one more case for balance, and that's a more recent judgment, which was Poundland Limited and Top Lane Limited. I won't go into the details, but just one point from that case is that a disputed term was whether or not a COVID or rent suspension clause should be included. And the tenant sought to rely on the previous Smith's case. And actually the judge did not agree with the tenant and sided with the landlord here. And I think it's just a good reminder that the OMA case is still relevant. So even though market conditions have changed, and yes, there will be discussions over rent and particular clauses, the law hasn't actually changed. It's still the OMA principles that apply. And so a party proposing a change will need to justify that change. It's not automatic. You can't just say because of COVID. So there's still work to do there. And in fact, actually, so the variation reflecting market practice can't just be the tenant's only argument. And I think in that case, the court was reluctant to approve any variations, which too far shifted the risk to one party. So again, it's back to that fairness principle.
Cool. Okay. Well, I'm just conscious of time, Amari, so I think we'll probably leave that there, and we'll move on to Mark, just so we've got enough time to cover everything that you want to cover, Mark. So I guess really looking in terms of insolvency, what is news in terms of the insolvency world at the present time?
Well, briefly just recap on the changes that were made last year. So Michael's already mentioned the changes that were brought in to assist recoveries against tenants. He's mentioned the fact that there were restrictions on winding up petitions against corporates as well. But there was some balance brought to that as well back in the summer of last year, with new processes that were brought in effectively to assist primarily debtor in possession type recovery strategies for corporates and businesses as a whole. So there was a new procedure that was brought in, which enables a business that can predict a solvent outcome rather than an insolvent outcome, to effectively appoint a monitor to manage a moratorium that can last for up to a year, but is renewed repeatedly in consultation with creditors, that can support a structural or financial process towards a full solvent restructuring, but provides it with protection from enforcement in that process. Another is schemes of arrangement. Schemes of arrangements have been is a corporate strategy that's been around for decades, frankly. But this new system, this new procedure is also now available to enable those creditors or shareholders that won't have an effective financial interest in an alternative outcome, for example, in insolvency, for their votes to be excluded from the process by the court in circumstances when the court decides that actually they're not going to have an economic interest in this outcome because that's the nature of the business as it is. So those are two changes that were brought in last year. And Mike's already mentioned the restrictions on winding up petitions. As he said, that only applies to corporates, it doesn't affect individuals. One of the other aspects that they brought in with a view to protecting directors was a limit on the risks for directors of claims against them by a company that's gone into liquidation of a claim for wrongful trading. That's essentially where the directors ought to have properly concluded that the company couldn't avoid insolvent liquidation, but allowed the business to trade on. In those circumstances, a liquidator can make a claim against them as individuals to make a contribution to the losses that were effectively suffered in that period when they should have brought a close to the business. Essentially, where those businesses were effectively affected by COVID, there was a general inability to advance those claims. So it was a bit of a get out of jail free card for that sort of claim. That came to an end in July. But fundamentally, quite a lot of us in the sort of the insolvency profession have said, look, the key issue here is not whether or not you can avoid insolvent liquidation. You've got to just look to your duties. Because if you're carrying out your duties properly as a director, you should be okay and avoid insolvent trading anyway. The risk is that it wasn't a free pass. If a director has been in breach of their duties, they've still got potential liabilities and damages if and when it can be proven. So those are some of the changes that have been made in the last 12 months.
Okay. And what about pre-packs? Because I understand that there have been sort of some changes in this sort of area as well.
This is fairly new on the statute book, as it were. Regulations came in the last few months, and it relates to pre-packs for administrations when an administrator has been appointed after the 30th of April. A pre-pack is essentially a commercial agreement for the transfer of the business or part of the business that's negotiated by an administrator before he's appointed, and then normally perfected on the day of their appointment. The advantage of them is that enables a business that's been struggling, is effectively insolvent, to plan and deliver a disposal of the business at good value to a willing buyer at a price negotiated independently by an insolvency practitioner and the buyer. Generally speaking, they're good for the business. They're good for the underlying creditors as a whole. The risk is that they are not liked. They're not liked because quite a few of them are brought into effect by the same managers and directors buying the business back effectively on the same day. They're not seen by many as actually delivering value, and they're seen by many as a stitch up, and they don't have the relevant transparency. So some time ago, there was a consultation on how to improve that, and effectively that was reflected in far more substantial reporting to creditors, far more consultation and independence, and having to report on the promotion of the business for sale. That led to the development of a system called the pre-pack pool, and it was a voluntary exercise whereby the purchasers could go to the pre-pack pool and effectively get a bit of a supporting statement that was then revealed to the administrators and then revealed to creditors. It wasn't compulsory, and the government decided it wasn't enough. So with effect from 30th of April, they've restricted the powers of the administrator to sell, and it doesn't affect all pre-pack administration. So for example, you can think of a sale to a competitor that hasn't got anything to do with the current management. You'd expect that to be negotiated on an arm's length basis far more independently, because there isn't that inherent risk of conflict of interest. But when there's a connected party, the administrator cannot sell unless he's complied with one of two conditions. And so he can either go to the creditors and obtain that approval from the creditors. The difficulty is that plays against the advantages of a pre-pack sale, because you end up with a position where the administrator has been trading, incurring substantial costs. You've got a risk of decline of the business. So that's unlikely to be the preferred option. The other is that the administrator insists that the proposed purchaser, the connected party, gets an independent evaluation report. If that independent evaluation report is compulsory, it comments on the consideration and the terms of the agreement, and is then delivered to the administrator. The administrator can then decide whether or not he then proceeds or renegotiates. If he proceeds, he can still do so, because frankly, it might be the only offer that he's got available. But if he does, he then has to disclose that report to the creditors, subject to confidentiality issues, and also comment on why he's proceeded with the sale and not done some other process, for example, a liquidation. So that's a new innovation. It's welcomed by many. The question is whether or not it will be followed through and effectively provide the credibility to the process that many desire. It is relatively new. There haven't been many that have gone through, and certainly the reports won't have come through yet, because the reports on those processes only get delivered in sort of 8 to 10 weeks, and there's been few cases that have come through, so far as I'm aware, that have been involved connected party sales in that period since the 30th of April.
Okay, so in terms of the new procedures, how have they developed in the last 12 months or so then?
Well, so in the context of pre-packs, as I said, they're too new really in terms of this change of emphasis. In terms of the monitor and the moratorium process, there have not been very many appointments, and my view on that is that's partly because there's been such a positive cooperative approach in terms of forbearance, and there aren't the normal triggers that would force a business into an insolvency process, like a winding up petition or the revenue turning up on the door and seeking to recover goods and so forth. So there have not been the normal tensions that have caused a company to make the demonstrative step of engaging in a process that effectively protects the business against creditors. So there haven't been that many monitor appointments. There have been a number of schemes that have come through. Like the old style schemes, they tend to be directed towards the larger corporates, and certainly the larger corporates have dominated this space over the last few months. There's been a number of that have come through, but they are proving to be astronomically expensive. I was told last week that one of the costs of trying to get through a scheme was about £1 million. In that context, it is until this has been tested by those larger cases unlikely to be in any way viable to any mid-market or even small listed business, let alone the owner-managed enterprise sector. But equally, one of the reasons they're complicated is because there are so many people involved and classes of creditors that makes them really quite complicated. We've obviously faced Brexit in the last few months. For any international business, that's completely changed the landscape of some of the processes that are available, and that's certainly been dominating some of my time over the last 6 months. There's one other small addition, which has been an annoyance to many creditors, which is that sometimes companies just fall off the company's house register. They've just been dissolved, they've failed to file their annual return or accounts, and then they're just dissolved. There's a new process that was brought in the last couple of months that enables the Insolvency Service to look at what happened and potentially disqualify directors when that was inappropriate. That's some of the context of some of the changes.
Okay. So, and what about landlords then? What action can they take?
Well, as Mike said, they've had the landlords have had their arms tied behind their back to some extent. We've certainly seen, and I've certainly seen, some debt recovery action taken, and certainly consulted with some landlords on whether and what the advantages of that would be, rather than, for example, waiting until the window of opportunity to forfeit a lease or take back possession when that window closes. That window has now been pushed out to next March. But in the meantime, certainly some landlords have gone ahead with debt recovery action with a view to getting third-party debt orders, for example, where they're able to enforce the claims against the companies that owe their tenant money. That's just not suitable for some businesses, for example, retail, where they may not, where it's not retail, but hospitality, where their effectively revenues are by credit card payments for the restaurant bill. They are still pursuing claims against guarantors, and that's an important consideration for all landlords. But it's also an important consideration for the management of the tenant, because the guarantor is normally a director of the tenant. So it does then have an impact on the business as a whole, because quite often the financial support of the tenant is through those individuals to some extent or another. Certainly, we've got one significant case where we've got the landlord has got a long lease and is looking to make recoveries against the previous tenants. And we were looking at one case which has got some very long leases in it, and some significant historical tenants that are now making claims amongst themselves, which are not in fact covered by the same level of restrictions that are between a landlord and the tenant, because it's a matter of indemnity and not lease. So there's one other point which many landlords and the whole industry is familiar with, which is retail CVAs. Many multiple site retailers have advanced CVAs. A number of landlords have challenged those, claiming that they're unfairly prejudicial to them, either because they've been put in the wrong slot, or in fact the bargain is too difficult for them and too onerous on them compared to other creditors. Generally speaking, the processes have been supported by the courts when they've been challenged. There was one recent case in relation to the Regis CVA, which was essentially overturned. But by the time it was overturned, the company had already been into administration. So it was something of an Pyrrhic victory, but it was certainly a rap on the knuckles for the participants involved to make sure that the presentation of the proposals to the creditors and landlords as a whole, because it is generally the landlords that are suffering in those circumstances, are fair and reasonable. A key factor in that, though, is that not all CVAs relate to large retail chains, and landlords can take a demonstrative and changing approach to proposals if they've got enough voting power. And the larger the arrears of rent, the more likely the landlords will have voting power, and the more likely they can influence those CVAs.
Cool. Okay. I'm just conscious of the time out. You've got 3 minutes basically. I know you wanted to cover the COVID rent arbitration scheme. I'll briefly, do you want to just run through that?
Yeah, I'll do it very briefly. And the key is that a live landlord and tenant scenario doesn't normally involve a reduction in rent, apart from by mutual agreement, and that's what the protocol encourages. The nature of insolvency processes is that normally there's a compromise of the landlord's claims by the process. This new structure through the arbitration that Michael has said is really quite uncertain at the moment, will change the context in which tenants and landlords will contemplate either forcing a tenant into insolvency processes or how that is considered. Because if we get to, for example, September, there's an opportunity of presenting a winding up petition, but by which date we may have some draft legislation. It may well be that it changes the context and the negotiation structure for those discussions, and whether or not a tenant is contemplating protection through an insolvency process, or whether the landlord is going to face a disputed claim for the rent that they may be claiming, because the tenant might say, well, it should be compromised through the arbitration scheme. So it's a bit of wait and see, but I certainly think there's been quite a lot of activity in that context over the next 6 months.
Okay. Lovely and perfect timing, may I say, as well, with a minute.
That's chance, that is.
I'm sure it's not. So, ladies and gentlemen, we're just about at 5 o'clock. We haven't had any questions that have come through. If anybody does have any points that they want to fire through to me or any one of the panelists that have been here this afternoon, I'm sure they'd be more than happy to take your questions or your calls. All I can say is thank you very much for joining us. As I said, we had a lot of ground to cover. I hope you found that very, very informative. I have, so that's been absolutely. Oh, just a minute, we do have.
It's just a thank you, I think.
Thank you, yeah, which is great. So I hope everybody has a very pleasant evening. Go and sit on out in your garden and have a cold one. I think is probably the best advice for everybody. But thanks again, folks. Bye then.
Thank you.
Thank you. Cheers.